Give me another one of these. I want to raise that. Thank you. And I'm going to start my... Okay. Let's see. You can let me know if you can find it. Good afternoon and welcome to the room. I hope this is going to be another informative session for you. And if you are here and present, can see and hear me, then go ahead and say hi in the chat. I'm going to keep popping my eyes down there to see who is here to join me. Welcome back to another session of Ask Judge Carol, where we take the law out of the courtroom and into your living room. So for those who might happen not to be too familiar with me, I'm a former magistrate and deputy registrar of the Supreme Court of the Bahamas. I'm an attorney with something over 30 years of experience, about 15 years on the bench, and the remainder of that in practice in the Attorney General's office and in private practice, where I also had my own law firm for a number of years. So that's a snapshot into who I am. Now, why are we here? I'm here because I've seen how people feel when it comes to going to court or having to interact with the court on any kind of level. And I'm on a mission to take the mystery out of going to court and or interacting with the law. So I believe that the law is not hard. It's actually there to help you, and it's not our enemy, and it keeps us from falling into chaos. So the law has an important role, and it affects all of us at some point or another. So with this show, I'm going to pick one topic each week and break it down for you in plain language and show you how it applies to you and help you navigate the law as you move through in your everyday life. So if you have any questions, you can drop them in the chat while we're live, or you can submit questions maybe for another occasion if you don't catch this one live by going to my website, www.judgecarol.net, or you can send questions via WhatsApp to 242-451-4855. Okay, so that's my little bit of housekeeping. Now let's get into it. So today I'm tackling a topic that just about everyone is going to have to deal with at some point, and that is the topic of probate. Now, this is really a vast topic. There are many parts to it, so I'm going to break it down into at least two parts, and this may actually be a three-part mini-series in the Ask Judge Carol session series. So first of all, I'm sure you have an idea that when you hear probate, you think about, okay, someone has passed and now I have to do something with the property that they're owned. So probate is that process where it closes the legal gap between when someone dies and passing on their property to their beneficiaries, their survivors. And from a technical standpoint, there's the technical term probate, which means when someone dies and they have a will, and the will is probated, meaning it's proved in court to be real and valid, and authorizes the executor to deal with the property. But there's also the generic term probate, which means even if someone died intestate, meaning they didn't have a will, and the personal representative has to file paperwork in court and get a grant from the court which recognizes them as the personal representative or administrator. So I'm going to use the term probate to refer to either of those scenarios, because we're going to talk about the process. Okay, so the probate is when the court legally confirms who has the authority to deal with the deceased person's estate. Again, if there's a valid will, the probate is granted to an executor. And if there is no will or no executor available for whatever reason, and there are several circumstances, then there is a grant of letters of administration. So you have a grant of probate and a grant of letters of administration. But either way, someone has to make an application to the court for a grant, and that entitles them then to deal with the person's estate lawfully. And without a grant of probate, what happens is family members can basically be locked out of the estate, not get to take the benefit of it. So last week I talked about wills and why it's good to have a will and being able to leave property for a beneficiary. And so if you have a survivor, once you have family members surviving you, whether there has been a will or there has been no will, then in order for your survivors or the survivors to deal lawfully with the estate, then they have to apply to the court. And I'm sure there are many persons who are watching this that know about incidents where families have broken apart. There have been big fights, disagreements. People fall out of relationship with each other. Family members not speaking to each other over a want of probate. So I think one point that I would want to stress here is that if you have a relative and a loved one that has passed on, the estate has to be probated. The property doesn't transfer by heir. It can't. The law doesn't recognize that just because you were a spouse of someone, that you are a relative, a child or a sibling or a parent or grandparent. It's not just the blood relationship, that it's not merely the fact that there has been a blood or legal relationship between the parties that authorizes and allows someone by law to deal with the property of a loved one. There has to be that nexus where the court steps in and identifies or acknowledges the person who is rightfully entitled to deal with the property, whether they inherit it all or whether they distribute it to the persons who are the beneficiaries. Either way, there has to be, the court is going to make an intervention. That's what the Probate and Administration of Estates Act of the Bahamas provides. And I believe all territories, certainly the Commonwealth territories, but in the UK, in the United States, all over the world, the law recognizes that when a soul has passed, then in order for property to be transferred to survivors, the court has to put a stamp of approval. So that's fundamentally what we're talking about with probate. So that's why I say at some point, everyone is going to have to encounter probate. So what are the steps then? So if you have to go through probate, what are the steps? So you locate the will, if you know one exists, or if there isn't one, then you move to the next step, which is you obtain a death certificate for the deceased, and you will have to then approach the court. Now, I'm talking about going to court, but really you're going to need to retain a lawyer for the process. Why do I say that? This isn't really a DIY, do it yourself kind of process. The law is very strict and stringent about how you prove who the persons are, who are the inheritors and the beneficiary of the estate, because a judge signs off on that grant. A judge of the Supreme Court signs off on letters of administration and a due process of proof listing all of the assets of the estate, identifying who the lawful beneficiaries are according to the rules and laws of the jurisdiction, and that all of the properties owned by the deceased have been listed and brought forward to the court. So it is a very stringent process. I think you'll be pleased to know, because it can't be just anybody who applies to the court to get a grant of probate. There are rules of degrees of inheritance, or in the case of a will, there are provisions as to how the property is to be distributed. It's indicated in the will, and then the executor or the administrator, once they have received a grant from the Supreme Court, can now proceed to distribute the assets of the estate. So you will engage an attorney to prepare the paperwork and submit it to the court. And it's filed in the probate registry, and then there's a period of review by the court once all of the paperwork has been submitted. And once the court is satisfied on all of those grounds, and the person applying has to also take an oath and swear that they have submitted a true and perfect inventory listing of all of the assets of the deceased person. And then once the court is satisfied that everything is in order, then a grant of probate or grant of letters of administration for the estate are issued by the court. So that's a very broad and basic outline as to the process of probate and why it is necessary. So what I'm going to do now, I don't have any questions that have come into the chat that I can see so far. So I'm going to reference a couple of questions that I've received and answer those for you. So someone has asked, how would I know if my mother's estate has been probated? Well, you would have to ask your lawyer to do a search at the probate registry, and you would have to give them the information as to the time of, your mother's passing, and then there are records at the registry that they would search. Then another question is, how do I know what assets were included in my mother's estate? So remember, I would have said a few moments ago that the executor, or if there was an administrator, they have to produce a listing to the court. And these are documents that are prepared on oath to say, these are the properties that are comprised in the estate. And so they make a list. So your lawyer will be able to, once the grant has been made and then the fact of the grant, now it's a public document. that is searchable in the registry, then you can look and see what was listed. And it's important for personal representatives that they do that, because if you are going to purchase property from them, from someone, and they say, oh, I inherited this from my mother, there is going to need to be evidence that that property was declared to the court, because that's part of how the chain of title is passed on. Again, which is why it is so important for applicants and the court that, and it's a very stringent process for proving, submitting an application for a probate, and why it is scrutinized so closely. Another question, are there any outstanding debts, claims, or disputes involving the estate? So the settling of debts is a primary responsibility for an executor and an administrator of an estate. And that must be done before any beneficiaries are able to receive their inheritance. So again, this is why it is important, and why you as a family member, or you as a beneficiary, want to see that the estate has been administered, that a grant has been issued by the court. Very, very important. Another question I have is, was a valid will ever submitted to the court? Now, this brings up another point that I would like to mention, because if you are making a will, or if you know if a loved one has made a will, you should let someone know that you've made a will. There's also a provision in the law for wills to be deposited at the Supreme Court registry. And so you let someone know, I've made a will and it's been deposited at the Supreme Court registry. Ordinarily, outside of that, wills themselves are not public documents until such time as there has been a grant of probate. And that can be a cause for a lot of confusion, as you can imagine. Was there a will? Wasn't there a will? Or sometimes someone suspects that there was a sorry about that. So that's why it's important to let someone know that you've made a will. They don't have to know what's in it, but you let them know that you have one and where it can be located in a safe place. So either with the registry or with your attorney. Let's see. Are legal heirs required to be notified of the probate proceedings? So if there is a will, then there is no notice that is filed by the person, by the executor. If there has been no will, and there's going to be an application for a grant of administration, and you can file a caveat if you suspect that, or you want to ensure that you are notified. You can file a caveat with the court so that you are notified in the event someone else makes an application for a grant of administration to your loved one's estate. So that is all the time I have for today. And I would like to invite you, if you have any particular questions, maybe that I haven't covered here, or you want to have the opportunity to have a private conversation with me, then you could reach out to my office at 451-4855 and arrange a 20-minute one-on-one consultation, or you can send a note through my webpage at www.judgecarol.net, or email info@judgecarol.net. Because I want to stress, I should have said this at the beginning, but I'm going to say it now. What I'm providing here is information. This is not legal advice. It is very important that you contact your own attorney to get the specific advice for your situation. I'm here to offer guidance and support and help take the mystery out of the law. And like I say, if you have a question, sometimes what I find is that you may need a little bit more understanding, and then you can take that information and that understanding and approach your lawyer and let them draw up whatever documents need to be drawn up. I'm here to provide general information, guidance, and support and take the mystery out of the law. So you can WhatsApp me at 451-4855 or info@judgecarol.net. I also have a tip sheet or a checklist for things you need to know information for if you are going to make a will, and you can complete that document and then take that to your lawyer so that they can draw up a will for you and avoid the conflicts and breakups and disputes that happen when someone dies without a will. If you'd like a copy of that free document, you can email me at info@judgecarol.net or message me at 451-4855. Next week, I'm going to go a little bit deeper into the probate process. As you can see, it's quite broad, and I was really only able to skim the surface today. Thank you so much for tuning in, and do come back next week for another session, another informative session of Ask Judge Carol. Thanks. Enjoy your afternoon.